Good morning, everybody. Welcome to the Smart Center and welcome to the U.S. Cybercom Legal Conference, the first in-person conference in 3 years, and I'd like to thank you all for coming, for showing up. We are exceptionally proud to finally get back together after learning how to deal with this in COVID. But it's great to be able to be once again together in person to discuss, debate, and break some bread, hopefully, in the same room as one another as we discuss the issues that are now confronting us in cyberspace and the law. Of course, I'd be remiss if I didn't note that one of the silver linings of the pandemic was how we learned to act virtually. And thanks to the professionals at the Defense Media Activity, we're able to bring this conference to several other people who couldn't be in person by live stream. And so I just wanted to extend my personal thanks on making this possible. That also means that we're going to be able to be very careful with our scheduling because we're sticking to a program to enable us to reach thousands of people in dozens of time zones around the world. This year's conference will focus on how U.S. Cyber Command, guided by our national defense strategy, will build enduring advantage through campaigning to support integrated deterrence. That's a mouthful. More to the point, we're going to explore how domestic and international law and those who practice it in this fascinating domain help the command, the department, and our nation defend and advance our national interests in collaboration with domestic and international partners. So I'm proud to share with you that this year's in-person conference attendees comprise practitioners in cyber from the public and private sectors, from across the interagency legal community, and of course, 12 of our foreign partner nations. I'm sure that all these groups and the live stream audience represented, and I hope you're all excited to hear from this incredible lineup of speakers and panelists from all corners of the cyber legal practice. There's three big things I'd like you to take away from this conference. So if you could focus on these things, that would be great. First, I hope we can all engage with the substance, right? Integrated deterrence is at the core of our national defense strategy. What that means has generated a lot of discussion and debate in the legal, academic, and policy communities. General agreement, though, is that it necessitates not only a whole of government approach to marshal all instruments of national power, but also close collaboration with the private sector and our allies and partners. You're going to hear a lot about partnership and legal instruments to facilitate partnership, I think, over the next couple of days. You'll see all these topics and more reflected in our conference agenda. These are exciting times, and they lend themselves to the rich legal discussion that we hope we're going to have. So that's the first takeaway. Number one, please engage with this topic, what it means to each of us, to our clients, and with the legal issues it poses for us, and hopefully what we can do as a legal community to help the United States and our partners maintain our edge. So, second takeaway, I hope you engage with one another. It's great to be back in person. On the surface, we want this conference to be an enjoyable event. We want you to have a good time, in which in-person attendees can catch up with old friends, make new ones, build out your Rolodexes. Who knows what a Rolodex is? We know that's an important part of in-person events, and that's why we're so grateful to be back together. It's a little tougher for virtual attendees, I recognize that, but I've gotten emails before saying, hey, I saw you speak at this event, or I was on this Zoom presentation that you were on. Those two are valuable connections that open doors, and so for those of us on our live stream audience or who watch this recorded who want to know more about cyber, we want to talk to you. On a deeper level, we want the speakers and the conversations and the discussions that they generate to spark an enduring commitment to furthering our understanding of how the law applies to cyberspace in this domain and our diverse legal subcommunities. And those aren't just words. We know success in integrated deterrence is going to require a whole of government approach. That's the whole point of integrated. I hope we'll hear more about what it means to be integrated throughout the week. And we know that legal interoperability and transparency with our foreign allies and partners and collaboration with the private sector is going to be critical, things that we still have time to work at. And that's important because collaboration is hard. You know, going back to the interdepartmental charge that George Washington led at the Whiskey Rebellion, up through, you know, the laser focus after 9/11 on breaking down barriers to allow information sharing between the many, many national security players, collaboration is where we get things done as a government and as a community of partners in the international space. So that's the second key takeaway. Please take the time, make the effort to get to know each other, to compare notes on challenges and successes, and to share your different perspectives. Third, finally, I'd like for you to engage with our U.S. Cybercom team. You'll see my team of talented legal professionals and our extended family of component judge advocates throughout the week at all these events. They come from all the services. They are some of the very best at what they do. I hope you take the time to get to know them, ask them questions, find out more about our unique practice of law. This is challenging, but especially important for those of you who are attending via live stream, especially those who might be interested in joining the practice of cyber law who may not yet have had the chance to do so. But I'd encourage you to reach out. We love our jobs. We really do. This is great stuff, and we would love to tell you why if you're interested in becoming a part of our practice. So please reach out. In addition to Cybercom's judge advocates, this conference gives us the opportunity to hear from some of the smartest, most experienced, and most knowledgeable cyber professionals in the military space right here in the command. You'll get to hear from Admiral Heidi Berg, our Director of Plans and Policy and Strategy, who will share valuable insights on building a global network of partners. Ms. Holly Baruti, our Executive Director, is going to talk about collaboration and working with the private sector. And of course, you get to hear from the man who wears many hats, the Director of the National Security Agency, the Chief of the Central Security Service, and for my purposes, the most important is Commander of U.S. Cyber Command, General Paul Nakasone. We'll get to hear from him this week. All of those U.S. Cybercom senior leaders who regularly grapple with the most high-level and complicated national security challenges, they understand the importance of what we do, of legal advice throughout the national security space. They're here, and they're coming here because they all believe, just as we do, that the discussion of these issues amongst those represented here makes us better as a national security team, makes us smarter, and makes our teams better able to take an integrated approach to national security. All that said, there's no better speaker that I can think of to kick off these impactful discussions than our first speaker, and it's my absolute privilege to introduce the Honorable Carolyn Krass, the General Counsel of the Department of Defense. Her depth of experience in both the public and private sector and nearly every corner of the interagency community gives her a unique perspective on these issues as we work to achieve integration in cyber law. She's been the CIA General Counsel before her current job. She served 2 tours at the National Security Council Legal Advisor's Office, 2 tours in the Department of Justice Office of Legal Counsel, including the Acting Associate Attorney General. She's been at the Treasury Department, the State Department, the U.S. Attorney's Office for the District of Columbia, practicing national security law. She's also served in the private sector as Deputy General Counsel of a couple of private corporations and a partner and chair of the national security practice at a major law firm. She's a brilliant legal mind, but this town is full of those. What sets her apart? She's approachable. She's extremely generous with her extremely valuable time, despite a long history of her responsibility. And why? I believe she does it because she wants to elevate our practice. She helps us be better lawyers through her analysis, through her writing, and through her very example. And so that's why she's the senior attorney of one of the largest legal enterprises in the federal government. She's the senior attorney over 14,000, I believe, attorneys in the DoD, which is a great example to make us all better. And so therefore, I think she's ideally positioned and experienced to help us understand how we can integrate throughout our government, throughout the private sector, and with our international allies and partners. Please join me in giving a warm welcome to Ms. Carolyn Krass.
Good morning, everyone. It's a real pleasure to see a number of familiar faces here and to get a chance to meet those of you I haven't yet met. And thank you, Pete, for that incredibly kind introduction. And thank you also to General Nakasone for, along with Pete, inviting me to be here. This conference, as you all know, for those of you who have participated previously, is really a tremendous venue, just as Pete was explaining. I understand that last year, over 6,000 people participated virtually. When I mentioned this to a couple of folks yesterday in the halls of DoD non-lawyers, and I told them how big the population was last year who signed in, they looked very puzzled, almost as if they couldn't imagine that there were that many lawyers who'd be interested in cyber. So I know that we are all already convinced of the fascination of this topic, and I'm delighted to talk to you about implementing integrated deterrence in the cyber domain and the role that we serve as lawyers. This this year's theme is especially timely in light of the current challenges we face as a nation. The release last fall of the Biden administration's national security strategy and the national defense strategy, which is nested within it. As the President explained in the 2022 NSS, we live in a decisive decade, marked by dramatic changes in technology, geopolitics, economics, and the environment. In response, the Department of Defense has adopted a strategy to address this new reality and maintain our competitive advantage. The 2022 National Defense Strategy sets forth the Department's approach to advancing the defense of our nation, paced to the growing multi-domain challenge posed by China. The NDS focuses on deterring strategic attacks and aggression while being prepared to prevail in conflict if necessary. A key component of that NDS is integrated deterrence, which is a holistic approach to addressing our competitors across domains, across DoD components, and the U.S. government, and with our allies and partners around the world. In the current strategic environment, we see our competitors in cyberspace seeking to steal our technology, undermine our military advantages, threaten our critical infrastructure, disrupt our government and commerce, weaken our collective prosperity, and challenge our democratic processes. The scope, pace, and sophistication of this cyber activity continues to rise around the world. Under the framework of integrated deterrence, the Department is countering these malign cyber activities by taking action to generate insights about the adversary's cyber operations and capabilities, to enable the government, industry, and international partners to create better cyber defenses, and to act to deter or, when necessary, to disrupt adversary cyber actors and halt their malicious activities. Our success in the cyber domain depends on maintaining an ability to move quickly and cohesively with key partners within the United States and around the globe. And the law is an integral component of furthering these strategic objectives. Today, I'm going to elaborate on the role of the lawyer in advancing integrated deterrence, with a focus on the cyber domain. Lawyers are essential to successfully achieving integrated deterrence. And DoD lawyers have a profound obligation to ensure that the Department's activities are conducted consistent with applicable domestic and international law. A key priority for my office is ensuring not only that we follow the rule of law in our own work, but also that we as a department promote that rule of law around the world. And working with our allies and partners, some of whom are represented here today, requires a recognition that we might at times be subject to different legal obligations or adopt different interpretations of certain legal rules, while ensuring that we remain aligned on core issues wherever possible. Determining the shape and contours of domestic and international law raises challenging questions that we wrestle with as an international legal community, which includes our civilian lawyers, our judge advocates across the U.S. government, the legal advisors for our allies and partners, as well as civil society, including academics and non-governmental organizations who are important participants in today's conference. I'm going to highlight some of the challenging questions and how we're thinking about them, specifically focusing on evaluating cyber operations against the international law framework of prohibited intervention and countermeasures, as well as the First and Fourth Amendments to the Constitution. Before I dive into how lawyers help further integrated deterrence in the cyber realm, I'd like to spend a few moments on what integrated deterrence means. The 2022 NDS defines integrated deterrence as, quote, using every tool at the Department's disposal in close collaboration with our counterparts across the U.S. government and with allies and partners to ensure that potential foes understand the folly of aggression, end quote. My colleague, Dr. Colin Call, who is the Undersecretary of Defense for Policy, has explained that integrated deterrence is a reminder that successful deterrence must seamlessly incorporate tools from every domain, including, of course, space and cyber, from every geographic theater, and from multiple instruments of national power, including not only our military activities, but also diplomacy, economic tools, and others. Integrated deterrence spans the spectrum of competition and armed conflict to include gray zone activities and immeasurably benefits from the critical assistance of our allies and our partners. The ultimate goal is a comprehensive approach to deterring conflict and, should it arise, keeping such conflict at the lowest possible level. This is particularly important when nuclear powers are involved. There are three key ways in which the United States enhances integrated deterrence. First, managing escalation. Second, campaigning. And third, prioritizing interoperability amongst our allies and partners. In recent years, the cyber domain has taken on increasing importance in each of these areas. And law, of course, plays an essential role as well. As lawyers, mastering a deep understanding of the relevant international and domestic legal guideposts enables us to explain to our policymaker clients the full menu of legally available policy options. Turning to the first concept, escalation management. This is inherently linked to deterrence. State activities in the cyber domain have the potential for certain escalation, especially when there are insufficient collective experience, common understanding, and established norms of behavior to allow competitors to correctly interpret intent. Against this backdrop, lawyers have an opportunity to support integrated deterrence by clearly articulating the legal standards, working alongside policymakers to develop and implement norms of responsible behavior, and helping to provide a vocabulary for states to communicate expectations and red lines, all with the objective of adding a measure of predictability to cyber-related interactions between state actors. Legal practitioners play an important role in ensuring that states do not misinterpret actions in cyberspace and thus risk inadvertent escalation. Another way in which the United States enhances integrated deterrence is through campaigning. The NDS defines campaigning as the conduct and sequencing of logically linked military activities to achieve strategy-aligned objectives over time. Campaigning is a daily effort to close warfighting vulnerabilities, shape the perceptions of our competitors, and sow doubt that achieve their objectives, directly countering our allies or our partners. In the cyber domain, campaigning occurs through day-to-day contact with our competitors. It includes operations to degrade competitors' malicious cyber activity and to prepare cyber capabilities to be used in crisis or in conflict. And it happens primarily in the gray zone. What we mean by the gray zone is the spectrum of competition below the level of or outside the context of armed conflict. Here, too, we as lawyers play an important role in advising on the types of activities that might cross thresholds under international law, such as whether an activity could constitute a prohibited intervention or a use of force. Ensuring our planners understand the applicable legal rules can facilitate the development and deployment of complex and enduring campaigns. Finally, the U.S. enhances integrated deterrence through interoperability with our allies and our partners, which enables us to work together as one team. Some of our allies, like the United Kingdom and Japan, have adopted strategies which include elements that are similar to our national defense strategy's approach to integrated deterrence. Interoperability with our allies and partners is particularly relevant in the cyber domain, in which, as you all know, technology transcends territorial boundaries and effortlessly brings us into contact with others around the world. To operate most effectively with our allies and partners, it is important to have common understandings of the respective legal frameworks governing our actions in cyber. Lawyers have already played a vital role. States now generally agree that international law applies in cyberspace, and along with NGOs, civil society, including academia, states have made tremendous progress in clarifying how various aspects of international law apply to cyber operations. And of course, dialogue continues regarding how particular rules of international law apply to specific scenarios in cyberspace. That's what keeps us in business. There's always room to create more commonality and thus enhance integrated deterrence. I want to talk a bit about international law. Our clients fully embrace the importance of adhering to international law. One of the key precepts of the 2022 National Defense Strategy is the promotion of a rules-based international order. International law is the framework that states have adopted to set binding standards for their behavior, serving as an established pillar of stability and order in the international system. States have committed to abide by international law, not only in their interactions with each other, but also, in many respects, in their treatment of their own nationals and others within their territory who are subject to their jurisdiction. International law can provide guideposts that states use, both to criticize unlawful conduct and to respond together to such conduct. The United States believes that our compliance with international law in the cyber domain is a foundation for the legitimacy of our military operations. As former State Department legal advisor Harold Koh presciently said over a decade ago at one of the very first Cybercom conferences, where he clearly set forth the U.S. government view that international law applies in cyberspace, quote, "If we succeed in promoting a culture of compliance, we will reap the benefits. And if we earn a reputation for compliance, the actions we do take will earn enhanced legitimacy worldwide for their adherence to the rule of law," end quote. Clarity, predictability, and shared understandings of the law play the same important role for deterrence in the cyber domain as they do in other areas of state conduct, whether in competition or in conflict. But in contrast to many other areas of state activity, outsiders are rarely able to observe state cyber behavior directly. As a result, the cyber domain often affords minimal public visibility into the two preconditions for establishing customary international law: general and consistent state practice, and opinio juris, which are statements affirming that a state is acting out of a sense of legal obligation. As a result, there's heightened value in states continuing the public conversation regarding how specific rules in international law, whether established by treaty or by custom, apply in cyberspace, and publicly identifying violations when they occur. Increased transparency enhances legitimacy and predictability by helping to develop and strengthen expectations surrounding state behavior, as well as public responses in the rapidly evolving cyber domain. We must therefore continue to recognize the applicability of international law rules to state activities in cyberspace during both peacetime competition and an armed conflict, and we must continue to develop our understanding of how those rules apply to the conduct of our military operations. The U.S. has previously articulated certain aspects of our interpretation of international law in the cyber domain. For example, we have affirmed that a state's inherent right of self-defense, recognized in Article 51 of the UN Charter, may, in certain circumstances, be triggered by cyber activities that amount to an actual or to an imminent armed attack. And we have affirmed that states conducting activities in cyberspace must take into account the sovereignty of other states, including outside the context of an armed conflict. One important, but perhaps often overlooked, method for advancing the conversation regarding specific rules of international law is to raise questions for discussion. By asking these questions, states can identify areas where the particular application of the law is less clear. The purpose of identifying these unanswered or underexplored issues is to prompt the entire legal community, many of whom are represented here, as well as policymakers, to consider and to work toward resolution of these questions. Over the balance of my remarks, I'll focus on summarizing the current state of the law in two important areas of the international legal architecture below the threshold of armed conflict: prohibited intervention and countermeasures. And then I will identify several questions that remain the subject of discussion and debate regarding the application of those legal concepts in the cyber domain. I will conclude with an explanation of how our military operations in cyberspace are conducted consistent with both the First and the Fourth Amendments to the U.S. Constitution. My goal in doing this is to advance the public conversation about and understandings of these rules, thereby contributing to the advancement of integrated deterrence, as set forth in the National Defense Strategy. Beginning with the customary international law rule of prohibited intervention, it is a concept that is also reflected in certain treaties that the U.S. has joined. As the International Court of Justice, or ICJ, described in the merits judgment in the case concerning military and paramilitary activities in and against Nicaragua, The rule of prohibited intervention forbids states from engaging in coercive action that bears on a matter that each state is entitled, by the principle of sovereignty, to decide freely. Prohibited intervention thus plays an important role in protecting state sovereignty and preventing interstate disputes, contributing directly to the goals of integrated deterrence. Although the scope of prohibited intervention is generally understood to be relatively narrow, certain peacetime activities of states in cyberspace could run afoul of the high threshold. The U.S. has previously said, for example, that a cyber operation by a state that interferes with another country's ability to hold an election or that manipulates another country's election results would violate the rule of non-intervention. It is widely recognized that prohibited intervention has two elements. One, the action must interfere in matters that the targeted state is permitted to decide freely under the principle of sovereignty. And two, it must be coercive. But the precise meaning and contours of these elements are not well defined, and cyberspace magnifies these already existing uncertainties. Working with our allies and partners and appreciating the contributions from civil society to advance the understanding of these fundamental concepts can contribute to the broader goal of a shared and more nuanced view of how international law applies in cyberspace. So let me start with describing the matters a state is permitted to decide freely under the principle of sovereignty. Many commentators refer to these matters as a state's domaine réservé, and here I'm helped by my high school French, or reserved domain in English. Although the United States does not publicly use that phrase in formal writings, I'm going to use it today as a convenient shorthand in describing past and current discussions on this topic. As the ICJ said in the Nicaragua merits judgment that I mentioned earlier, one matter within the domaine réservé is the choice of a political, economic, social, and cultural system and the formulation of foreign policy. Although the ICJ expressly limited its discussion to those aspects of prohibited intervention that it considered most relevant to the resolution of the dispute in the case it was deciding, one abiding question remains. How can we better understand the contours of which activities are matters that a state is permitted by the principle of state sovereignty to decide freely? The term domaine réservé appeared in an advisory opinion of the Permanent Court of International Justice, which was the precursor to the ICJ. In that opinion, the PCIJ was assessing the scope of a dispute resolution provision in the Covenant of the League of Nations, which did not apply to disputes arising out of matters solely within the domestic jurisdiction of a state. In assessing the legality of French decrees that imposed French nationality on all persons born in Tunis or Morocco, which had the effect of converting British subjects born in the French zone into French nationals, the PCIJ used the term domaine réservé to capture matters of a state's affairs that are solely within the jurisdiction of a state. The PCIJ noted that some matters, such as, in principle, nationality, are not governed by international law and thus are part of a state's reserved domain. The court observed that the parameters of the domaine réservé will evolve over time because whether a certain matter is solely within a state's domestic jurisdiction was a relative question that would depend on a state's obligations to other states and to the development of international relations. The PCIJ was not addressing the prohibition against intervention, and its remarks do not govern this distinct issue. But the history I just explained may help give us a sense of what some people have in mind when they refer to the domaine réservé. In today's interconnected world, having a sharper understanding of the parameters of matters that a state is permitted by the principle of state sovereignty to decide freely could contribute to clarity and predictability. Against this backdrop, a number of states in recent years have begun to explore how the concept of prohibited intervention applies in cyberspace. They've identified additional areas that, in their view, fall within a state's domaine réservé for purposes of prohibited intervention, including elections and, more recently, healthcare. For example, last year, the United Kingdom identified domestic healthcare, financial markets, energy supply, and elections, all as falling within its domaine réservé for the purposes of prohibited intervention. And the United States in 2021 identified manipulation of a state's election results or coercive interference in a state's ability to hold an election or to protect the health of its population as potentially constituting violations of the rule. In this respect, certain aspects of a state's provision of health care could be part of its domain reservé, regardless of whether administered by the state or predominantly through the private sector. Italy and New Zealand have also suggested that coercive interference in health care could violate the rule on prohibited intervention. As states consider how to develop their thinking further on the domain reservé, as understood for purposes of prohibited intervention, some may look to historical sources. For example, in its Nicaragua judgment, the ICJ looked in part to the 1933 Montevideo Convention, to which both Nicaragua and the United States are parties. The Montevideo Convention provides that each party to that treaty has the right to organize itself as it sees fit, to legislate upon its interests, administer its services, and to define the jurisdiction and competence of its courts. But at the same time, and as the PCIJ observed, states will want to bear in mind that the parameters of a state's domain reservé will depend in part on its obligations to other states, which can develop over time. To give one example of particular importance in the cyber context, by becoming parties to the UN Charter, all states today have agreed that certain matters are unquestionably matters of international concern that may be regulated by international law, such as the prohibition on the use of force in Article 2.4. Articles 1.3, 55, and 56 of the Charter each commit UN member states to respecting international human rights. This, in turn, has led to the development of human rights treaties. States that are parties to such treaties have consented to legally binding obligations aimed at protecting specific human rights, such as the freedom of expression, freedom of association, and freedom of religion or belief. Under this international human rights regime, excessive regulation of online content, including censorship and access restrictions, cannot be justified as a sovereign prerogative. And as the United States has reaffirmed, any regulation by a state of matters within its territory, including use and access to the internet, must comply with that state's applicable obligations under international human rights law. Having explored the matters a state is permitted by the principle of state sovereignty to decide freely, I want to turn now to the second element of prohibited intervention. The activities must be coercive. While coercion can mean different things to different people and in different contexts, the scope of coercion for purposes of prohibited intervention remains particularly under-theorized and underdeveloped. It is well established that a use of force against another state would be coercive. But on the other hand of the spectrum, actions to which a state voluntarily consents, such as by joining human rights treaties like the ones I just mentioned, are inherently not coercive. So where on the spectrum between voluntarily consented to behavior and a use of force does coercion begin? The threshold for assessing whether an act is coercive in the context of prohibited intervention seems to be most clearly satisfied when a state has in fact been compelled to take or refrain from taking a particular course of action. For example, a cyber operation that manipulates another country's election results or interferes with another country's ability to hold an election is coercive. Certain cyber operations that prevent a state from protecting the health of its population could also be coercive. Because relatively few states have made public statements regarding their interpretation of the coercion element of prohibited intervention in the cyber domain, opinio juris on this matter is still developing, and many questions remain ripe for further examination. One question relates to the degree of severity required for an act to be coercive. Although some may assume that a coercive action must involve force, because of course force is inherently coercive, such an interpretation is unduly limited. The prohibition against intervention makes sense as a standalone rule under international law only if it is distinct from the prohibition on the use of force, which means coercion for purposes of prohibited intervention in the cyber domain must include at least some acts below the threshold of a use of force. Another question focuses on the intended consequences of a potentially coercive act. Is coercion for purposes of prohibited intervention in the cyber domain limited to those instances where the act is designed to compel a target state to undertake a specific act or omission? Some states support that approach. Other states have adopted a broader view that any act that deprives a state of freedom of control over elements of its domain reserve would constitute a prohibited intervention. This broader approach may stem from a desire to hold states accountable for seriously disruptive conduct without requiring the targeted state to show that the conduct was meant to produce or induce a particular act or omission. But focusing solely on deprivation of control without more could turn any disruptive cyber activity by a state that affects, even unwittingly, certain elements of another state's activities into an unlawful intervention. A final question for further exploration is whether coercion must succeed for the act to violate the prohibition on intervention. The ICJ's Nicaragua merits judgment describes intervention as wrongful when done by methods of coercion, but does not address whether the method of coercion must be effective. Requiring coercion to actually produce the desired effect could have paradoxical results. It may disadvantage states that are better able to deflect or endure coercive acts because their resilience would foreclose the determination of prohibited intervention. And it could reward states whose attempted intervention fails. It could also mean that the same act directed towards two different states could be prohibited intervention against one state, but not the other, depending only on attributes of the targeted state, for example, whether a target state's cyber defenses were advanced enough to withstand the act. Such an outcome could impede the ability of states with more robust and resilient defenses to call out violations, and if desired and appropriate, to respond lawfully with countermeasures or other tools of international law. Before I turn to domestic law, I'd like to briefly address another topic that comes up frequently and raises challenging questions when discussing cyber operations in an environment of competition below the level of armed conflict: countermeasures. A countermeasure is an act that would otherwise be internationally wrongful, but for the fact that it is taken in response to an internationally wrongful act attributable to a state. Like international law writ large, the doctrine of countermeasures applies to state conduct in cyberspace, and it's an important tool for states that are victims of violations of international law, including, potentially, as a response to a violation of the rule of non-intervention. Indeed, as the United States has previously affirmed, a state injured by another state's cyber activities that constitute an internationally wrongful act but do not amount to an armed attack may respond with non-forcible countermeasures in the cyber or any other domain. As in other domains, the lawful use of countermeasures in the context of peacetime cyberspace activities has several requirements. First, the countermeasure must be taken in response to an internationally wrongful act attributable to a state. This factor reaffirms the importance of resolving the earlier discussion of prohibited intervention, particularly whether an attempted but unsuccessful intervention by coercion constitutes an internationally wrongful act. Second, the countermeasure must be taken against the responsible state for the purpose of inducing that state to return to compliance with international law. Third, the countermeasure must meet the requirements of proportionality and must be suspended without undue delay if the internationally wrongful act has ceased. In the United States' view, whether a measure is proportionate should be measured in relation to what is necessary to induce the breaching state to cease its wrongful conduct, as well as in relation to the size or gravity of the original breach itself. In addition, countermeasures are generally understood to be temporary measures and should therefore be reversible to the extent possible. Finally, as a general rule, an injured state preparing to take a countermeasure in response to an internationally wrongful act in cyberspace attributable to another state must call upon the responsible state to cease its wrongful conduct, unless the need to preserve the injured state's rights demands urgent countermeasures. The purpose of this requirement is to provide the responsible state with notice of the injured state's claim and the opportunity to respond or cease its wrongful conduct. But in practice, such a notification in the cyber domain calls for further exploration. For instance, what if notification and demand for cessation of another state's internationally wrongful act would compromise a cyber operation that would be urgently executed as a lawful countermeasure. In that case, it is possible that the need to preserve the injured state's rights would justify taking action without prior notification. Similarly, what if notification and a demand for cessation would tip off the offending state that a clandestine cyber operation will follow if that state does not cease its activities? In addition, can the doctrine of countermeasures have any applicability to assist a state that has been a victim of a cyber operation that has been completed and is already irreversible? Suppose the internationally wrongful act in which a state has engaged involves hack and leak activities. How could a demand for cessation or a resort to countermeasures bring the responsible state back into compliance once the hack and leak aspect of the internationally wrongful act is complete, because the leak cannot be reversed? It would seem relevant to this analysis whether there's also the expectation of further internationally wrongful acts occurring. The doctrines of prohibited intervention and countermeasures are fundamental to peacetime stability and predictability in the international system. And as the questions and discussion I offer today highlight, they are ripe for further examination in the cyber context. By furthering these conversations, we as lawyers can make an important contribution to succeeding in competition and achieving integrated deterrence through the continued development of common understandings in the cyber domain. I'm going to turn now to a brief discussion of U.S. domestic law, focusing on military cyber operations against and affecting systems located outside the United States. The U.S. Constitution plays a significant role in safeguarding privacy and civil liberties, as DoD seeks to deter and protect against adversary gray zone activities in the cyber domain in a lawful and effective manner. As lawyers, we help our clients advance integrated deterrence and also hold true to the Constitution by delineating legal guideposts in domestic law, just as in international law. I will focus today on the First and the Fourth Amendments. The First Amendment is, of course, foundational in protecting free speech in the United States. As we combat efforts by our foreign adversaries to use disinformation and other influence operations in their attempts to further their own interests and to undermine our most cherished values, we must remain steadfast to the First Amendment as a critical touchstone. Concerns about foreign influence in our political processes have existed since the founding of our republic. We see this in the Constitution itself. For example, in the Emoluments Clause, which the framers adopted in order to protect U.S. officials from corruption and foreign influence. Combating malign foreign influence remains a key component of our national defense. So what roles does the First Amendment play? Of course, we all know that the First Amendment protects Americans' rights to speak freely. The picture becomes more complicated when we look abroad, where foreign speakers generally have no First Amendment protected right to speak. This is certainly true of foreign states that wish to interfere with our electoral processes. But the Supreme Court has also interpreted the First Amendment as protecting Americans' right to receive information and ideas, regardless of their social worth. This right to receive information encompasses, for example, the freedom to read and receive news and information about current events and other matters of public and private interest. In several cases, the Supreme Court has recognized that Americans have a right to receive information from foreign speakers abroad, at least under some circumstances. In a 1965 case called Lamont versus Postmaster General, the Supreme Court struck down as unconstitutional a statute that required the Postal Service to hold communist political propaganda, as it was then termed, that was mailed to Americans from abroad and permitted release of that mail only upon an affirmative request from the intended recipient. And in a 1972 case called Kleindienst versus Mandel, the Supreme Court recognized that Americans' First Amendment right to receive foreign information was implicated when the government precluded a Belgian citizen from traveling to the United States to deliver lectures. These protections recognized by the Supreme Court are vitally important. We must therefore, as lawyers, carefully consider how to harmonize two interests: the right of the state to prevent foreign influence on government functions and the right of the individual to receive speech. For example, there may be some tension between Americans' right to receive speech and the nation's interest in preventing foreign influence on U.S. elections. As legal practitioners charged with both defending the nation and upholding the Constitution, we must navigate these issues. The First Amendment's protections, including the right to receive speech, are rooted in a belief that a robust political debate is essential for an informed electorate and a healthy democracy. At the same time, the protections of the First Amendment are not so expansive as to prevent the nation from defending itself. Accordingly, the analytical framework and case-specific evaluation of cyber operations require careful consideration of potentially competing interests, including the nature and strength of the governmental interest and the scope and tailoring of the impact a cyber operation may have on protected First Amendment rights. The role of the government lawyer in these circumstances is especially vital because such matters often will not be adjudicated by our courts. It's incumbent upon us as executive branch lawyers to abide by the Constitution, respect civil liberties, and uphold the rule of law, while at the same time protecting national security. I'm going to turn now to the Fourth Amendment. As we work to achieve integrated deterrence, it's advantageous to understand our adversaries' plans, intentions, and capabilities. Accurate intelligence enables us to calibrate our deterrence efforts and integrate those efforts across domains and with allies and partners. Today, cyber is a critical domain for gathering intelligence, and such intelligence, in turn, is vital to the conduct and development of cyber operations. Cyber operations also have the potential to lead to the incidental collection of intelligence to inform decision makers and future activities. As we evaluate cyber operations from a legal perspective, sometimes the Fourth Amendment will come into play. The Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, and limits the circumstances under which warrants can be issued. Its basic purpose is to safeguard the privacy and security of individuals against arbitrary invasions by governmental officials. Core Fourth Amendment principles guide our cyber operations. For example, the Fourth Amendment protects U.S. persons, whether they're in the United States or abroad, and generally protects other persons while they are in the United States. Much like the First Amendment, however, non-U.S. persons located outside the United States generally will not be protected under the Fourth Amendment. Cyber operations targeting such persons overseas, therefore, generally do not implicate the target's Fourth Amendment rights, because those targets do not have any Fourth Amendment rights in the first place. So why am I talking about the Fourth Amendment? In the globally interconnected cyber domain, there is sometimes a chance that activities that are targeting a foreign adversary will result in the incidental acquisition of, for example, communications to which a U.S. person is a party. When a cyber operation implicates Fourth Amendment rights of U.S. persons, further analysis is needed. And that brings me to my second principle. The Fourth Amendment prohibits unreasonable searches and seizures. In the domestic law enforcement context, a search generally must be conducted pursuant to a warrant based on probable cause. But the ultimate touchstone of the Fourth Amendment is reasonableness, and neither a warrant nor probable cause is an indispensable component of reasonableness in every circumstance. In most cases, cyber operations targeting non-U.S. persons located outside the United States do not implicate the warrant requirement. The warrant requirement generally would not apply, for example, to such searches conducted abroad or to otherwise lawful surveillance that targets persons lacking Fourth Amendment rights, but incidentally acquiring the communications of a Fourth Amendment protected person who was not targeted. Even in contexts that do not require a warrant, a search implicating the Fourth Amendment must satisfy the reasonableness requirement. This entails a fact-sensitive evaluation of the totality of circumstances, balancing an activity's intrusion into protected privacy interests against the degree to which that intrusion furthers the government's legitimate interest. When cyber operations directed against foreign adversaries implicate the Fourth Amendment rights of, for example, U.S. persons, there will often be significant interest to balance on both sides. Where a cyber operation targeting a foreign adversary implicates the Fourth Amendment because of incidental collection, two criteria help to guide our review. First, we look at whether our collection methods are adequately focused and controlled to produce the required intelligence without unnecessarily invading the privacy of persons protected by the Fourth Amendment. And second, We look at whether adequate precautions are taken to limit those invasions of privacy that do occur, an inquiry that can take into account post-collection procedures such as limitations on retention, dissemination, and querying. Lawyers across the government, including in the Department of Defense, help their clients work through these types of questions every day. In doing so, we advance the government's vital national security interests, safeguard Americans' privacy and civil liberties, and ultimately support integrated deterrence. In sum, government lawyers play an instrumental role on a daily basis in advancing integrated deterrence, including in the cyber domain. We do so not only by guiding policymakers on legally available options, but also by seeking to further the conversation on how relevant rules of international and domestic law apply in cyberspace. Clearer definitions can, in turn, serve as guideposts to our policymakers, ensure that our actions are consistent with our values, and help maintain our legitimacy on the international stage. Thank you very much.
You know we have to go through the thank you, and we have to give you the official Cybercom Staff Judge Advocate coin. No, thank you so much for coming. Thank you for those remarks, and I really hope that everybody keeps that framework in mind as we go through the more granular discussions throughout the week. So thank you once again, ma'am.
We are on break until 10:20. Please help yourselves to coffee and refreshments outside.
Hi, I'm Colonel Pete Hayden, and I'm excited to have the opportunity to engage with you all as a part of the U.S. Cyber Command Legal Conference. Whether you're in person or virtual, your interest and participation are critical to solving some of the toughest and most important and interesting legal topics our nation faces. While the conference is giving us all the opportunity to discuss emerging legal issues in this exciting area of practice, I also want to reach out on something near and dear to all of our hearts here at U.S. Cyber Command. One of General Nakasoni's priorities is attracting talented practitioners in diverse disciplines to the cyber enterprise. Through participation in this week's events, you should see exactly why that's so important to U.S. Cyber Command, to the services, and to the nation. The bottom line is this: we need you. And here's why you should want to join our team. The U.S. Cyber Command enterprise is one of the very few places in which attorneys routinely work side by side with partners from across the interagency. They also get the rare opportunity to partner with the best and brightest throughout the joint force and to be part of a high-functioning team comprised of talented attorneys from across the services. In addition to that, our judge advocates, civilian attorneys, and paraprofessionals work closely with the private sector, developing collaborative sharing platforms to advance national security interests and defend against malicious cyber activity. They also routinely interface with our international partners on everything from military exchanges and information sharing to synchronized and combined operations, furthering our interoperability and deepening relationships with our strategic partners. Here at U.S. Cyber Command, we develop relationships across the military services, industry, research community, academia, and the whole of government to facilitate innovation and foster collaborative sharing platforms in order to advance national security interests and defend against malicious cyber activity. It's baked into our statutory mission to direct, synchronize, and coordinate military cyberspace planning and operations to defend national interests in collaboration with domestic and international partners. Attorneys and paraprofessionals in the U.S. Cyber Command enterprise get the extraordinary opportunity to interface with operators and attorneys at all levels from across the intelligence community to develop military plans for intelligence collection and operationalization of all source intelligence to support cyber operations. Our practice is diverse. If you're a legal professional interested in the practice of national security or intelligence law, we can offer you the opportunity to help shape conversations and high-level, whole-of-government analysis on the interplay between these two disciplines and the ways in which we can work with other sector and other government partners to generate insights and options in defense of the nation, defend DoD information networks, and ensure mission advantage for the Department of Defense, and support combatant commands. If you're an administrative law or a criminal law practitioner who's listening in because you want to try something else, or you just find this work interesting, we can use your analytic abilities and advocacy skills to solve emerging problems and make lasting change. If you're a contract or fiscal law guru, please give us a call. The future of national security law is often fiscal law, because we need to fully understand how to marshal our resources and acquisition authorities to enable our operators, maintain our technological primacy, and keep us the finest fighting force in the world. We are in a competition for talent, and we can always use more in the unique, demanding, and highly rewarding practice of cyber law. In short, we need you.